Good morning. I think we're probably 12 o'clock. I think I'm being given the green light that everything is up and running. So good morning, everyone who has joined us. I am, for those who don't know, Simon Trigger. Sat alongside me, hopefully you can see on the screen, is Pressman. We're both here today to talk to you for about an hour, hopefully, on two topics. The first is non-party costs orders, and the second is fundamental dishonesty. Both of those will be by way of effectively a cost update, a case update, rather than a root and branch examination of the two topics. There is, I hope, a question and answer function on your screens. If you wish to use that, please do so. I think just for ease of running, we'll deal with all questions at the end, but please put them in the question and answers boxes, and we'll come on to them. If you've put them in chat as well, we'll check there at the end, and hopefully we'll deal with all of those questions. I think without further ado, it's probably time to start. Just in terms of background, for those who don't know Decker Chambers or myself or Bernard, we are a set of chambers who deal with a number of different areas, but primarily for the purposes of this talk, personal injury and credit hire are two main areas. We have particular expertise in dealing with dishonest claims or claims that arise in relation to that framework, and therefore that hopefully will inform the talk that we're going to give. Bear with us if the technology doesn't work, but I'll give it a go now. The first part of the talk is on non-party costs orders. Just by way of background, just for those who are less familiar with what a non-party cost order is, you'll all be aware, of course, that the basic starting point is that costs are inter partes, between the parties who are before the court. Section 51 of the Supreme Court Act, which I put the text on the screen there for you, however, gives the court a much wider power than merely inter partes cost orders. Paragraph 3, or subsection 3 of Section 51, is pretty wide-ranging. It simply states the court shall have full power to determine by whom and to what extent the costs are to be paid. It's important to bear in mind that this talk and the focus of this talk is on non-party costs orders. That is different to wasted costs, and those are two discrete topics. Of course, wasted costs is usually a claim against a party's legal representatives, and can give, who are strictly not parties and therefore, I suppose, are technically the non-party. But a different body of case law has developed in relation to wasted costs, and in relation to the circumstances in which a legal professional should or should not be made liable for costs. So this talk is not about that. This talk is focused upon non-party, i.e., in old-fashioned language, third parties, not the legal representatives and not the parties before the court. It's also important to bear in mind, when we come on to look at some of the more recent cases, the power for the court. Section 51 gives rise to the statutory basis. CPR 46.2 sets out the practical and procedural powers of the court when dealing with an inter partes costs order. 46.2, again, we'll come on to look at what that means in a moment. Again, it's important to distinguish that from 46.8, which, as you can see on your screen there, is dealing with what I would describe as wasted costs, or costs against a legal representative. 46.2, which then is the starting point in terms of the procedure for a non-party costs order. Again, I'm going to take it relatively quickly just to bring people up to speed with what this whole topic is about. You'll see there that when the court's considering exercising its power under Section 51, there is a mandatory provision that that party must be added to the proceedings for the purposes of costs only, and be given a reasonable opportunity to attend a hearing at which the court will consider the matter further. I pause there to note that whilst that is clearly what 46.2 says, and I've just quoted it there, that has in many cases been slightly fudged. So, for example, what is meant by a reasonable opportunity is quite often given quite a lot of latitude. It may well be the court takes the view that you knew a non-party costs order was going to be made, and therefore, even though an application hasn't yet been made, that was your reasonable opportunity to attend the hearing to consider it further. So just be warned, even though the strict requirement is that if you're thinking of making a non-party costs order, or if you're potentially at risk of one being made against you, you should technically be added to the claim, should then be given an opportunity. There is effectively a two-stage process. but it doesn't always happen. Some trial judges particularly get sort of infused in the moment, and having decided the case then go on and effectively try and decide non-party costs as well. They shouldn't do, but they do sometimes. One of the things, I'll come on to it in a moment, one of the things that's important in relation to joining up, how the court deals with non-party cost order, is that there's various authorities that indicate that it's proper for the trial judge, when the non-party cost order arises from a trial, or from the procedural judge if it's arising from an application, for that judge to also deal with the non-party costs application. It's not mandatory, it's not built into the rules. You can see there the rules don't say it has to be the same judge, but various cases have made it clear that precisely because, as we'll come on to look, there has to be a close connection between the non-party and the litigation that's given rise to the application, it is far preferable, and indeed should always be the case, that the trial judge or the procedural judge deals with the non-party costs application as well. I'll come back to that in due course. In terms of the case laws in the background, a useful starting point, it's quite historic now, is Dimmock and Todd back in 2004. A couple of points to pick up on, and these are repeated throughout the cases. You will often hear it said that non-party cost orders are, quote, exceptional. And they are. But as Dimmock and Todd makes clear, and as numerous cases since have made clear, exceptional just means not the normal, which I suppose is a definition of exceptional, but it's quite a wide definition of it. The normal is inter partes costs, and so almost by definition, an application for a non-party cost order is exceptional. So it isn't really any form of jurisdictional threshold. It arises precisely because you're making an application for costs against somebody who isn't the party. A couple of the points from Dimmock and Todd I've put on this screen precisely because I'm sort of flag it up now. I'm not entirely convinced this is how the courts still view non-party cost orders. So, for example, paragraph 2, you'll see generally the discretion will not be exercised against pure funders. That's people who have no personal interest in the litigation. It has to be someone who has some control over the litigation. I'll come back to that in due course. Paragraph 4 in particular, I want to place particular focus on. Dimmock said a non-party should not ordinarily be liable for costs which would in any event have been incurred without the non-party's involvement in the proceedings, although the position may be different where a number of non-parties have acted in concert. Now that might lead you to think that where you would have litigation anyway, and where there would have been a claim anyway, so if we think in a credit hire context, a case where liability is an issue, for example, so therefore there had to be litigation to deal with liability, or a case where there's a personal injury claim and a loss of earnings claim from the personal injury and a credit hire case, it might be thought that paragraph 4 of Dimmock would lead a non-party into a safe place, because the non-party could easily say, well, that litigation was always going to happen. The cost of the litigation to sort out liability, to sort out the personal injury, to sort out the loss of earnings was always going to be incurred. Yes, there's an extra claim for credit hire, but it's added very little to the overall case, and it certainly hasn't given rise to the cost of the proceedings. Dimmock and Todd would suggest that was a good argument. I'm not convinced it is any longer, for reasons that we'll come on to in due course. Now, I segue from the general rule to qualified one-way cost shifting. Again, for those who aren't involved in any personal injury, qualified one-way cost shifting is what QWOCs stand for, of course. 4416 is relevant in this context because in a case in which paragraph 2A, the proceedings include a claim which is made for the financial benefit of a person other than the claimant, that can be, on a discretionary ground, a basis in which an enforceable costs order can be made. Again, for those who aren't aware, I'm sure you all are, but under 4414, etc., qualified one-way cost shifting means that a claimant with a personal injury claim is not liable for costs to be enforced against them. The cost order can still be made against them, but it can't be enforced over and above any actual award of damages. Paragraph 2A will become relevant because it deals with proceedings which include a claim made for the financial benefit of another person. And you can see there at paragraph 3 of 4416 Where that applies, the court may, subject to Rule 46.2, which is what we've just looked at, the general power for non-party cost orders, may make an order for costs against a person other than the claimant for whose financial benefit the whole or the part of the claim was made. That is important and has, of course, given rise to lots more non-party costs applications, because many defendants are faced with claims where there is a personal injury claim, but also a credit hire claim. Commonly, a credit hire claim vastly over and above the value of the personal injury claim. Particularly, of course, with the new whiplash reforms, the personal injury claim may be only worth a few £100s, and we've got thousands of pounds of credit hire. And it may well be the defendant succeeds, but because of quox, the argument would go, there is a non-enforceable cost order against the claimant, who in fact may not be good for the money anyway. And so it is thought, and I think it's rightly thought, that CPR 4416 has caused all parties to look at non-party cost orders a little bit more carefully. And certainly the first tranche of cases came out through this prism, through 4416. What is important to note, therefore, just before we move on, is that in order for this to be relevant, the proceedings, which is the claim as a whole, has to include a claim made for the financial benefit of a person other than the claimant. A little bit of guidance is then given in the practice direction to Part 44, and you can see that it's my bold that I've added to 12.2. Examples of claims made for the financial benefit of a person other than the claimant or a dependent within the meaning, etc., are subrogated claims and claims for credit hire. I pause there because that is the useful pickup point for the first tranche of cases. I'll just leave the slide on the screen for a little bit longer before we turn to the authority itself. The relevance of the practice direction is that when you read that together with 4416, it appears to suggest that a claim for the financial benefit of another person would include a credit hire claim. That is the precise circumstances in which an enforceable cost order could be made. And then 4416.3 indicates that if that is what the court is thinking, it would be better to bring it against the non-party, subject to 46.2. Thought lots of defendants. The gateway is now open to go after the credit hire company, even in a quox-based case. And the first and the most important successful outcome of that is the case of Meehan Jones. Keep your eye on Justice Turner. He's going to reappear in a bit, and a little bit like Martin Spencer, Justice Martin Spencer is on a one-man crusade to reduce his insurance premiums. I think Turner is on a similar approach. Whether that's a good thing depends on your starting point. He dealt with an appeal from a recorder. It's also known in this case as select car rentals. That's important because most people refer to it as select car rentals. When you try and find it, you can't find it because you have to search under Meehan Jones. It is the same case, so don't worry. Meehan Jones is authority and has been affirmed in a number of subsequent cases, so it's good law. Firstly, as a headline, the non-party cost order was made against the credit hire organisation Select Car on the facts of that case. Just so you're clear why it has a subnom of Select Car Rentals and eSure, it'll come as no surprise to you. Jones's insurer was eSure, and me obtained their credit hire vehicle from Select Car. And so, in fact, even though me and Jones are the drivers, it turned into eSure against Select Car as a cost recovery exercise. The first point that was taken was whether or not CPR 4416 that we've just looked at is a new and discrete way to get non-party cost orders distinct from CPR 46.2. Short answer, no. It's the same, it's just a species of it, no new law, so therefore any cases under 46.2 are equally relevant. Second line of attack that was raised, the recorder having found that the non-party cost order should be made, second line of attack was to say that the practice direction that credit hire is a claim brought for the financial benefit of another party was ultra vires or was wrong. The argument being, of course, that in a credit hire case, the claimant has to have a legally enforceable contract with the credit hire company to be able to bring the credit hire claim at all. Therefore, technically, it's the claimant's liability that's just being then paid on to the credit hire company. And so it's not right to say it's for the financial benefit of the credit hire company. It's actually for the financial benefit of the claimant. It's his contractual liability. Might be thought some force behind that. Got very short shrift. The answer is it's in fact, he almost goes as far as it's a statement of the bleedingly obvious, that a claim brought for credit hire is for the financial benefit of the credit hire company, precisely because it's better to get some money, which they're going to get from the defendant, than limited, if no money, from the claimant, who is probably impecunious. That's why they're hiring on credit in the first place. And the mere fact that it might also be for the financial benefit of the claimant doesn't mean it isn't for the financial benefit of someone else. As a result of which, not ultra vires, practice of action is right when it says that's what a credit hire case is, and therefore held the recorder had jurisdiction and was correct in the jurisdiction that under 4416 a non-party cost order could be made. What's important in Me and Jones is the level of control that was found by the recorder. I'm just going to quote, it's not on the screen, and of course you can all look it up for yourself. I'm just going to give you a couple of edited highlights from Me and Jones as to the level of control that Select had operated over the litigation. On that case, Select had actually instructed the solicitors. They'd been in direct contact with Eshaw during the currency of the litigation. They had the express power to take the money out of the claimant's hands if it was for the credit hire. There was all sorts of irrevocable authorities given to Select Car effectively to conduct the litigation. Based on all of that, Justice Turner found, well, the recorder, not only was it within his reasonable discretion to make an order against the credit hire company, actually, because they had actively controlled the litigation, it was the right decision. Not all the costs were awarded. You'll see there on the screen only 60% of the costs of the claim were awarded. Importantly, paragraph E, and this is a repeating theme in all of the cases, the only immutable principle, that is whether to consider whether an NPCO should be made, is that the discretion must be exercised justly. I pause there to note, certainly my own view is that the word justly is a little bit like the word proportionate. It's used by judges to justify the outcome rather than being actually a test in its own right. But nonetheless, it is the test that's applied. The test is whether the discretion should be exercised justly. And of course, paragraph F makes the point that bringing a claim, even under the CPR 4416(2), merely because the claim is brought for the financial benefit of another party doesn't mean you're automatically liable for non-party costs order. It just opens the door. In fact, it's a necessary but not a sufficient condition for an order to be made. I mentioned a couple of points that I wanted you to bear in mind from Dimmock's. Select also said this, relying on Deutsche Bank and Sebastian Holdings, which is a 2016 case. It cited with approval the following. When an order for costs is sought against a third party, the critical factor in each case is the nature and degree of his connection with the proceedings. I should pause as well. Deutsche Bank also said, I quote, limited assistance is likely to be gained from the citation of other decisions at first instance in deciding whether to make a non-party costs order. I do realise that undermines the whole point of this talk, but it's, again, useful to know that the mere fact that one judge has made a finding on similar facts actually doesn't help very much. The immutable principle is it should be made justly. That decision somewhat opened the gateway, and defendants got very excited because on an appeal, a finding of a non-party cost order was upheld. I'm just going to skate through a couple of first instance decisions because having got to that point in Select Car, I think it's fair to note there was a significant rowing backwards in the favour of credit hire companies. So, for example, in the case of Shahzad and RSA, just a first instance decision in front of His Honour Judge Gosnell, no disrespect obviously to His Honour Judge Gosnell, district judge, even less disrespect to the district judge, had made an NPCO. I pause to note that in light of one of the cases we're coming on to, the district judge probably got it right, but anyway, let's put that to one side. The district judge had made an order and that was overturned on an appeal. And you can see there, the analysis of His Honour Judge Gosnell is that it's only by exercising control over the litigation that a non-party can be treated as, quotes, the real party in the litigation. The court must inquire whether the non-parties have controlled the proceedings for their own benefit to the extent they are the real party, or whether they have funded the litigation, which would not have taken place without their support. And Gosnell goes on, and I'm not going to read the whole quotation there. He goes on and effectively says that if where a credit hire company has not controlled the litigation, if a non-party costs order was made, well, that would expose all credit hire companies to the risk of paying successful insurers' costs. Because, of course, this only arises where a cost order is made in the favour of the insurer or the defendant at all. That has to be that starting point. And Gosnell was reacting against that and saying that, no, there has to be much more than that. There has to be control. Again, I'm not quite sure that's where we've ended up, for reasons I'll come on to. But as I say, Gosnell pushed very much back against it. I should say the district judge had found, as you can see at the top there, the credit hire company, as a finding, hadn't controlled quotes the litigation. On hire and Smithson, His Honour Judge Friedman, certainly no disrespect to him, had quotes extensively from Travellers. Now, Travellers is a case about insurance funders rather than credit hire per se. But you'll see there, he says that there has to be more than a shared commercial interest in the outcome of the litigation. The non-party has to be the real party to the litigation. They must control and direct the litigation, and its participation in the litigation will only render it liable for costs if, in running the litigation, it is not furthering the interests of the named party. So really quite a high threshold from XYZ, Travellers. You will see, I won't again read it out, paragraph 32 and 33, it says in terms in Travellers, in that context, you have to prove causation. In other words, the non-party can only be liable for the costs that they have caused. Again, quite a high benchmark, pushing back very much against non-party cost orders being made against credit hire organisations. On hire, as the name suggests, is a credit hire organisation. That was the context of that application. I skate over them precisely because, as Deutsche Bank made clear, we shouldn't excessively quote from first instance decisions. But secondly, I think because of that pushback, things have started to turn the other way. Some of you will be aware of the Suarez and Anexo case. Now, as a headline, this was a defendant insurer probably overreaching. The defendant insurer had settled the underlying litigation through a Part 36 settlement, and then a cost spat arose and significant costs were incurred in the cost spat, and the defendant insurer went after Anexo as a non-party cost order for the cost spat. Anexo, for those who haven't had the joy of researching this, is the holding company or the parent company, however you want to look at it, of the behemoth that is McCann's and or Bond Turner and or various other credit hire organisations, and therefore they, in a slightly unclear way, certainly from this decision, they have overarching financial interest in the outcome of litigation in which Bond Turner and McCann's are often a company who hire cars quite often to motorbikes, so moped drivers and the like, but also there's a similar body all under Downs, again, these terms that you don't need to worry about so much. Essentially, it's a one large corporate entity with lots of different limited companies within it, and the idea was to go after the head company, Anexo. The outcome of the case was that was an overreach, and in fact, I think, from memory, Anexo didn't even exist at the time that the cost spat started, but held that there's just no control, and therefore Anexo were too much at arm's length from the litigation to be in the fray. However, having given you the headline, there is a shift back towards non-party cost orders being made. You'll see, for example, that rather than being the causation being a definitive question, that you could only be liable for costs that you caused, instead, that just became one of the considerations. The court should consider the extent to which the non-party causes costs to be incurred. But the fact that they haven't caused costs to be incurred isn't a reason why a non-party cost order shouldn't be made. Likewise with control, you see an important aspect is the extent of the control. But control isn't determinative in Suarez. It's another of the factors, as is whether notice was given, as is various other factors, all of which allow you to look at whether the ultimate test, is it just to make an order, has been made out. On the fact of that case, it wasn't. But there is certainly, and anyone who's making a non-party cost order, there is certainly material in Suarez that just begins to push back against the idea that they have to direct to control the litigation to be liable, or they have to have actually called costs, which on hire and Shahzed effectively say in terms. So this pushes back the other way, and it indicates that actually those are just touchstones that you might expect to be present but are not determinative as to whether it's just to make a non-party costs order. I told you we'd get back to Turner. Turner comes back into the frame, and Kinderton's and Murta, which you'll see is quite fresh off the press, March of this year, is an important decision, and he has gone back effectively to Select Car. Credit hire organisation was found for a non-party cost order. Important on the facts of this case is that the claimant, just to change the facts slightly, the claimant was found to be fundamentally dishonest, and an enforceable cost order was made against the claimant. Unsurprisingly, not enforced because the claimant disappeared. And so that is when the defendant decided to go after Kinderton's, the credit hire organisation. A couple of important points from Kinderton's. Grounds of appeal. First argument that was raised was that the claim was not for the financial benefit of Kinderton's, it was for the financial benefit of the claimant. Short shrift, it does. Select Car was still good law, held the same thing. Control, and again, Turner's made the point clear now. The ground of appeal was that there was no evidence that Kinderton's controlled the litigation. They had various contractual terms that might have allowed them, for example, to instruct solicitors, for example, to require the claim to be brought, but there's no evidence they had in fact exercised any of those powers under the terms and conditions. You'll see there Turner says, well, hang on, control isn't a traffic light, as he put it. It's not red or green, either you have it or you haven't. It's a matter of degree, and what's key is not whether you exercise the control, it's whether you had any control. And you'll see the contractual terms tied the claimant into bringing a claim and continuing with it at the risk of incurring serious financial consequences. The serious financial consequences are the claimant would be liable for the credit hire. That's the financial consequence. And it matters little, if anything, that they're not in fact exercised. So pushing right back against the idea of control. And then causation pretty much killed off. The argument on appeal was that Eshaw couldn't show but for causation, precisely because there was a fundamental dishonesty argument, precisely because there were lots of other issues in it. Quoting Total Spares and Artes, it is just to make an order for costs against a non-party who cannot be said to have caused the costs in question. Pretty much black and white. Causation of cost is not a touchstone of whether or not you can have a non-party cost order. It's relevant, and if you can point to costs that have been incurred, that makes it more likely you'll get an order. But if you can't, if the litigation would have happened anyway, this is clear authority for the proposition that that doesn't prevent you from making the application. Because Travellers seems to say the very opposite, Travellers is neatly sidestepped. Travellers is said to be a, quote, intermeddler case. In other words, a case where someone's intermeddled in the litigation. In those circumstances, you might need some form of causation, but that's not a credit hire context. Credit hire context is a question of who the real party for the credit hire claim is. And if that's the issue that you're dealing with, causation isn't required. It's in fact a claim for their benefit. So pretty straightforward answer. I'm conscious of time. I'll just put the quotation there. You'll see it says in terms, therefore, on the circumstances of the case, without seeking down any general rules about credit hire, unhelpfully, not setting out any general rules, it was right to conclude it's just to make the order. And the recorder didn't even have to make any findings with respect to but for causation. They were exercising a degree of control, and it was neither fair nor just that it should be permitted to do so without exposing itself to the potential consequences of a non-party costs order. So, green light to non-party costs orders. As an aside, just as one more case I want to deal with, so I'm just going to deal very briefly with Amjad and UK Insurance. It's of Justice Ritchie of these benighted shores. It's a very complicated case because the defendant got it wrong. The trial judge found that it was a case with a personal injury element, and the court found that the credit hire claim, quotes, was a claim for the financial benefit of a third party. But then the judge, at first instance, ordered an enforceable costs order against the claimant That was under 4416(2)(b). Ritchie held that essentially 2A and 2B are as a binary test. You ask yourself, who's benefited from this claim? If it's the claimant, then you go into 2B. It's a mixed claim, to use the expression. It's a claim that involves personal injury and non-personal injury, and you can get an enforceable cost order for the non-personal injury element against the claimant. That's 2B. If it's in fact a claim against a third party, you look at 2A, because the third party has to be the party who benefits. That's important because the judge, having made the non-party cost order having made an order against the claimant, should have gone under 2A, and therefore it was overturned on appeal. Importantly, however, Ritchie made it absolutely clear a credit hire claim is A, almost always. In other words, it's for the benefit of the credit hire company. I finish therefore with the case of Pereira and others. Pereira and others, as you'll see from the screen, handed down on the 20th of June 2024, is only in front of His Honour Judge Saunders, but leading counsel on both sides is Direct Accident Management Limited, which is what DAML there stands for, had geared up, and the claimant, or defendant, the applicant, had also geared up with leading counsel. It also deals with 4 cases. So it doesn't describe itself as a test case, but it clearly was being treated as a test case. The 4 cases cover a mixed batch of circumstances in which you might come across. 2 of the cases had personal injury as well as credit hire, 2 didn't. Some of them settled by way of a low Part 36, some didn't. Some settled, some were dismissed at trial, 1 was dismissed because they hadn't paid a court fee. So it deals with a full range of factual scenarios you might be faced with. It was common ground in all the cases that Direct Accident Management Limited had hired, and again, some are bikes, some are cars, 2 are bikes, 2 are cars, and the company who hired it actually has a different trading name, whether it's bike or car, doesn't matter, it's Direct Accident Management Limited behind it. It was common ground that they had no active involvement in the litigation. They basically set up the hire car and then handed it over to the solicitors, and it proceeded on the basis that that was the end of their involvement. They did not intermeddle in the case, they didn't give any instructions. It was also common ground that they would effectively accept the outcome from their nominated solicitors with Bond Turner, but the claimant didn't have to instruct Bond Turner, they could have instructed other solicitors, so very much hands-off, very much arm's length. On all 4, a non-party cost order was made on those facts. On all 4, the amount, whether it should be the 100% of the costs or a percentage, has not been determined. So it doesn't give you assistance on that. But you will see from the quotations on the screen, the court went through the business model. And that they went through publicly accessible material on Annex A that we've looked at already, Bond Turner, Direct Accident Management, and pointed out from that the whole business model of certainly that entity is that they are hiring to impecunious claimants precisely because they are people who will obtain credit hire, and that because they're impecunious, they're not going to recover from the claimant, they'll recover it from the defendant. And it was built into that business model that they wouldn't actually ever recover from the claimant because they're impecunious. And it was built into it that the money would actually come from the defendant. Having gone through all of that, the court then held that it was entirely right, just to apply the test, to make non-party cost orders. Causation was not required, as I've put there, or but-for causation wasn't required, it's just a test of it. But the judge went on, and quoting from a case called Farrell, which is an old case of 2009, the Court of Appeal in that case had held that the institutional proceedings that involve a credit hire case were a direct consequence of the hiring of the car. And that meant that the hire agreement itself was an essential catalyst for the litigation starting. Well, that's true of almost all credit hire cases, because if it's credit hire, they're likely to be impecunious, they're not going to get the money from the claimant, that's the essential catalyst for bringing the claim. That's enough in Pereira to open the jurisdictional gateway to a non-party cost order. The specific elements that stopped this being exceptional, made this exceptional, because of course the court was concerned to make sure that non-party cost orders were still to be seen as exceptional. The 3 reasons given why this case was exceptional were as follows. 1, the initiation and prosecution of the case is directly linked to the hire of the vehicle on credit. Well, that's true of every credit hire case. 2, the secondary reason is the funding of the vehicle, i.e. the credit hire vehicle, by the credit hire company is what's described as the essential catalyst for the claim for credit hire charges. That's true of every credit hire case. And the principal financial reward is for the credit hire company. Those are the three things that make it exceptional. I venture to suggest that arises in almost every credit hire case. It's almost as if credit hire has become exceptional from the normal inter partes costs order. That, the court held, made those facts I've just delineated the real party to the litigation. Important, I'm just going to finish, and I'm conscious I'm eating into Bernard's time here, I'm just going to finish by reading what the court said in summary, having made those findings. And I quote, it's paragraphs 103 to 105, which I'll just skim read. It cannot be avoided that the respondent, that's direct accident management, conducts its business knowing full well that it charges much higher rates of hire and does so intending to make a substantial profit. It provides this service knowing that it seeks to recover all or part of its charges from the defendant in the action. As part of its contract, it requires the claimant to pursue the claim for the third party's own financial benefit or in default face an unpayable financial burden. It must follow, therefore, that the third party should bear the risk of a non-party cost order, and that is an order for costs against them. To do otherwise, in other words, to not order a non-party cost order, would be unjust in this overall scenario. We have moved a very long way from the starting point of this, that it is unjust not to make an order against a credit hire company in circumstances where their business model is to pursue credit hire for impecunious claimants. Watch this space, but the direction of travel is clearly towards more non-party cost orders being made. Obviously, I'll take any questions at the end. However, I'm now going to hand you over to Bernard to deal with fundamental dishonesty.
Thank you, Simon. That was really, really interesting and very useful, not least because I have an application for non-party cost order next week. As well as busy scribbling, making notes. Good afternoon, everybody. As Simon says, I'm here to give a brief update on case update on fundamental dishonesty claims. Obviously, well, I can just start with describing the three areas that the cases I'll be discussing today come within. The first of those, as you should hopefully be able to see on your screen, is the substantial injustice exception to Section 57 of the Criminal Justice and Courts Act 2015. Secondly, whether or not it's appropriate to make an order for indemnity costs where a defendant has made allegations of fundamental dishonesty or fraud and where those allegations have failed. And finally, whether or not it's appropriate for a court to make an order for an interim payment where fundamental dishonesty has been alleged. Now, I suspect that you wouldn't be here today if you didn't know what fundamental dishonesty was. In any event, just to put it in context, a very, very brief explanation. Civil Procedure or CPR 4416, I think it was about 10 years ago now, came in. And what it did is it really just codified jurisdiction, which had always existed really, for a court to wipe out a claim for damages, including the genuine part, if there were genuine parts of the claim for damages, where there has been dishonesty, although back in the day I think we would just simply refer to it as fraud. So that's what 4416 did and does. All well and good, but what is fundamental dishonesty? Quite a few judges, mostly at first instance, have tried to grapple with an explanation, with a definition. I think probably the earliest one is the simplest one and is so often the case with simple explanations, is indeed the best one. It's on a Judge Maloney, I think he was sitting in Cambridge, where the dishonesty went to the root of either the whole of his claim or a substantial part of his claim. Pretty straightforward. And I think, in fact, that's probably the only one which has been expressly approved of by the Court of Appeal. Lord Justice Newey in Howlett and Davis and GS expressly approved that was a really good definition to use to determine whether or not there's been or what fundamental dishonesty amounts to. You might remember Howlett as the case where the Court of Appeal said, look, you don't need to plead fundamental dishonesty in order to be able to make the allegation or make the submission at the end of trial that a claimant has been fundamentally dishonest, so long as the claimant has had an opportunity to be put on notice and to deal with it. Although Lord Justice Newey did say that could be as late as cross-examination. And I'll say not for the first time, or not for the last time today rather, it's going to be very case specific, of course. So, just very, very briefly, not really what I wanted to talk about today, but on that point, what can a claimant expect to have been told or to be put on notice by in order for that to have been satisfied? The court can say, look, the claimant has had an opportunity to deal with this. In 2021, 2022, there are a raft of High Court decisions dealing with this, and unfortunately all competing with each other. In my opinion, the one which is usually the one which is accepted most is this case here, you can see on screen. Nothing to do with Pinocchio. Andrew Jenkinson and Gary Robertson. And what was said there, it is in the interest of basic fairness that a claimant should be given adequate warning of and a proper opportunity to deal with the possibility of a finding of fundamental dishonesty. Now, what's interesting is that if you look at the second paragraph there, even in that case, it was said that the Section 57 defence, which I'll discuss momentarily, can be raised at a late stage, even as late as in closing submissions. Again, every case fact sensitive. On your screen now, hopefully you'll have what I regard as the other important High Court decisions from that period which deal with whether or not a claimant has effectively been put on notice. So, I'm going to refer in a second to the Section 57 defence because that takes us to the first significant case I'd like to discuss today. The issue arising whether or not there has been a substantial injustice, and that's taken from Section 57 of the Criminal Justice and Courts Act 2015. Now, you can see it there up on your screen now. Essentially, what Section 57 does is where a court is satisfied that a claimant is entitled to some damages, but the court also goes on to find that the claimant has been dishonest about either his or her, the primary claim, which is his or her claim for personal injury, or a related claim, that would be somebody else's claim for personal injury arising out of the same facts or the same course of action, then the court must, no, there's no discretion, the court must dismiss the primary claim, and you come to the words in bold, unless it is satisfied that the claimant would suffer substantial injustice, not just an injustice, but substantial injustice if the claim were dismissed. And that takes us neatly, I hope, onto the first case I'd like to discuss today, Williams Henry versus Associated British Ports Holdings Limited from this year. And it wasn't, in my opinion, others may take a different view, but in my opinion, it wasn't until this case, 2024, that we had any useful guidance as to what substantial injustice might mean. Typically, how can I put this, very well-reasoned judgment by Justice Ritchie, we have just that guidance laid out. Again, fact sensitive, consider all the facts of the case, consider all the circumstances of the case. But Justice Ritchie laid down 8 factors, which you can find in paragraph, I think, 178 of the judgment. Factor 1, I'll devote a variable amount of time to each factor, but this one, pretty obvious really, what it says on the tin. If the dishonest damages claimed were small or moderate compared to the size of the actual genuine damages, then that's going to weigh more heavily in favour of the substantial injustice ruling. Factor 2, again, pretty straightforward, where you've been much more dishonest, where it's really infected most of the claim, and that's going to weigh against defining a substantial injustice than it would if it were a small amount of dishonesty. Again, pretty straightforward. Now, factor 3 is, again, what was the effect of the claimant's dishonesty on the litigation as a whole? Did it increase? And this is my reading into it, but I think it must be right. Did it increase the time taken, the amount of work done by both parties, the amount of costs? Did the dishonesty create what might have been a 2-day trial into a 10-day trial? Things like that. And obviously, the greater the effect, the less likely there's going to be a finding of substantial injustice. Now, factor 4, this is the one where I'm going to put myself out on a limb. And I've been wrong before, wouldn't be the first time I'm probably wrong here, but I actually don't agree with the rationale behind this factor. I'll give you 10 seconds to read it, or how many seconds you want. Now, it's a very noble approach, and I think actually one that we can probably all get behind. The problem is there's no statutory definition as to what a substantial injustice might mean. But in my opinion, what it must mean is that there could be a substantial injustice to the claimant. Now, in my view, the way I read this, again, I could be very wrong on this, but it looks to me that Justice Ritchie is saying that there could be a substantial injustice to the taxpayer generally. That's right, and there are very good policy reasons as to why this could be a very sensible approach. I'm not sure that that may survive the rigours of an appeal for that reason, because I don't think that approach puts a substantial injustice onto the claim. Just my thought, like I say, I'm usually wrong, but food for thought. Similarly, factor 5 I have issues with. Again, very noble, very straightforward, and understandable approach, one I'm sure we can all get behind and agree with. My issue is that this might be read as irreconcilable between this and, was it factor 2 or factor 3, where there has been a lot of dishonesty which has infected the entire claim and has really caused lots of costs to be incurred and really affected the litigation. Well, then how do you, I'm not sure you can reconcile these two factors, and I'd be really interested to see how that plays out in due course. Factor 6, and personally I found this incredibly insightful and really interesting part of the judgment. And I think probably will be, again, just my opinion, will be the main battleground in the future. Why do I say that? What's being said here is that, and Justice Ritchie was very clear, that the trigger for whether or not there is a substantial injustice is the finding of fundamental dishonesty. That comes first. You only go on to consider whether or not there's been justice or might be injustice and whether or not that's substantial if there has been a finding first of fundamental dishonesty. Now, if there has been a finding of fundamental dishonesty, then that invariably means the court's going to have to make an adverse costs order against the claimant. Now, that might mean that the claimant's damages will be left in tatters. If there's been a finding of fundamental dishonesty and adverse costs order made, then it's probably going to have to pay out the defendant's costs, or a large proportion of them, from their damages. Depending on the nature of the retainer, probably have to do the same for their own lawyer's costs as well. Now, to pluck some figures out the air, the genuine damages might have been £1 million, and after the adverse cost order, who knows, that they're left with £10,000. And at that point, if the court's considering whether or not it would be a substantial injustice to wipe out the rest of those damages, well, I think they'd struggle to win that argument, because when there's only £10,000 left from £1 million, for example, you might say there's an injustice, but a substantial one, I would say arguably not. And I think that's why that's going to be a really interesting battleground, probably the main one in the future. Factors 7 and 8 I'll essentially read together for reasons which will become clear. And I'll tie those in with an example from this case, actually, which I love. I was just mentioning to Simon before we started. Really, really clever, I think, tactic from the defendant in this case. They had made a large interim payment earlier on to the claimant in order to buy a house, I think, which was more suitable for her needs. In this case, I should say, that we're discussing at the moment, it was a very interesting case. The claimant was doing reasonably well in life. I think she was working, ironically, for an insurance company, and she had some promotions ahead of her at work, perhaps. And she unfortunately fell off a pier and suffered a moderate, I think it was, TBI, moderate traumatic brain injury, but had an incredible recovery. She was doing really well in recovery, much like her attitude before the accident. She just embraced everything full on and was doing really well. So far, so good. Problem was, she then decided to lie all about it. And Justice Ritchie found, I think, that she lied to pretty much every one of the medical experts, and there are a lot of medical experts. So her whole case tainted with dishonesty. So the defendants had made an interim payment for her to, I think, buy a house, which was suitable for her needs. But what they said when they were making a submission that there should be a finding of fundamental dishonesty and the entire claim should be dismissed, they also encouraged the court to not order the repayment of the interim payment. Why? Because if the claimant then has to sell her house to pay it back, there's a really good argument at that point, and that's why I was considering factor 7 and 8 together, really good argument that there would be a substantial injustice. So to head that argument off, they made a calculated decision, a gamble, calculated risk to say, you can keep the interim payment, but we'll win big in getting all the rest of the damages wiped out. And it worked, and I think that was a really clever tactic. Very briefly, I'm going to mention Shaw and Wild, only because it is, I believe, the first and perhaps only case of its kind to be dismissed for fundamental dishonesty in a claim as big as this. At one point, the claim was pleaded at up to £6.5 million. And even the judge found that even the genuine parts of the claim were assessed at about £1.2 million. So a pretty sizable claim, and yet it was dismissed completely. And it was found that there was a substantial injustice was considered, and it was found that there was no substantial injustice in dismissing the entirety of the claim. Quite an interesting one if you have the time to read. His Honour Judge Sefton, Casey, I think it was, sitting as a judge of the High Court, gave his decision there. Again, I'm almost certainly wrong, but I wasn't sure. That's the theme of today, me being wrong. I wasn't sure that I personally derived much use from the comparator there, which you can hopefully see on your screens. The comparison there is, well, whether or not there's a substantial injustice. If you compare the claimant in this case to somebody who doesn't have a solvent or an insurance company with deep pockets to sue, well, then there's no substantial injustice when you compare the two. I think that's an arbitrary comparison myself. But again, I'm almost certainly wrong. But food for thought. Right. That takes me on to the next case. Hiran Thakkar and others versus AXA Insurance from this year. And as you'll see on the screen, it's within the context of fundamental dishonesty allegations and indemnity costs, whether it be appropriate to order that there should be indemnity costs if those allegations fail. If you take away nothing else from the talks today, and I say talks plural, that article next, which you can see the link for, is probably the best article I've ever seen, just by sheer coincidence written by me. It's what's useful about that article is it adds a little bit of flesh to the bones, which I'm about to talk about from this case. We don't have time to go into it in great detail, so it explains it a bit longer. If you can read the judgment itself, it's not massive, would be a good idea. So the article I've just referred to is titled Something for Everyone or Sources for Geese, and it's got that title for very good reason. In typical Court of Appeal fashion, when trying to give some guidance to clear everything up, it does nothing of the sort. It's very much a case of yes, no, maybe, well, it kind of depends. So what I have done for today's purposes is to try and derive from that judgment 3 takeaway points. The first of those points is that the claimants in that case were arguing that much like from other jurisdictions, so for example, the commercial courts, there is a presumption in these circumstances, and by these circumstances I mean a failed allegation of fundamental dishonesty, there is a presumption or a starting point that indemnity costs should be ordered. Lord Justice Coulson said not so, that's just not right. So that's the first point to take away today. Second point is what I consider to be the defendant's best argument derived from Lord Justice Coulson's judgment. In order for there to be an award of indemnity costs, there must be conduct or circumstance which takes the case out of the norm, and there has to be a surmounting of a high hurdle. So that's what the defendants will point to. Whenever they've made allegations of fundamental dishonesty, and if they fail, they say, this isn't out of the norm, and you have to surmount a high hurdle, which simply hasn't happened here. Now, when I said that yes, no, maybe, it depends, you'll see what I mean by what happened next. And I got the feeling when I was reading Lord Justice Corson's judgment that it was very much one big sigh, because he describes what I say is the claimant's best argument from his judgment, what he describes as a statement of the obvious. Because the making of a dishonest claim will very often attract an indemnity cost order against a claimant, a failed allegation of dishonesty will very often lead to the making of an indemnity cost order against the defendant on the simple basis that what is source for the goose is source for the gander. My advice, it's hardly groundbreaking, but my advice is for defendants considering making an allegation of fundamental dishonesty, just have a reasonable basis for doing so. You can't make it, a blanket approach, and I'm not sure anyone does, but have something to hang your hat on. And I was thinking about this over the last few days, and I think if I was sitting in the Court of Appeal and I wanted to create a test, I would simply go back to basic standard first steps. What would the person on the Clapham Omnibus think? Would the person on the Clapham Omnibus look at the case and say, yeah, I think there's a reasonable basis for you believing that the claim might be dishonest? And if you satisfy that test, and it's not an actual test, we've always out, that's what I think should be the test, then I think you're probably safe from a finding of indemnity costs where the allegations fail. Finally, and I'm going to speed up because I know that we haven't got a lot of time left, the subject of interim payments where there have been allegations of fundamental dishonesty. That's what was considered in the case of Kaiser Mahmood and Harry Mayer this year in the Court of Appeal. No, High Court, forgive me. The jurisdiction for the court to make that order where a defendant doesn't want to make an interim payment. Of course, I should pause here to say that defendant can volunteer, of course, to make an interim payment whenever it wants. Even if it's made allegations of fundamental dishonesty, it might well do so. But the jurisdiction can be found in CPR 25.71 and 25.74. Now, in order for the court to make an order for an interim payment, then at least one of the following has to be satisfied. It's not cumulative, only one of them, or at least one of them has to be satisfied, A or B or C. Now, if we look at 1A, the defendant against whom the order is sought has admitted liability to pay damages or some other sum of money to the claimant. Well, where the defendant has alleged fundamental dishonesty, especially Section 57 defence, fundamental dishonesty, well, it's done nothing of the sort. It's not admitted it's liable to pay a penny. In fact, it's asking the court to wipe out the entire claim, potentially even the genuine parts of the claim. So 1A doesn't apply. 1B, the claimant has obtained judgment against that defendant for damages to be assessed. Well, in this case, obviously, it hasn't, certainly not at this stage. And I suspect it won't be, there'll never be a judgment having been entered if the defendant is alleging fundamental dishonesty. 1C, if the court is satisfied that if the claim went to trial, the claimant would obtain judgment for a substantial amount of damages against the defendant. Well, it can't be satisfied because the Section 57 defence might succeed. So the court can't be satisfied that any damages will be payable. And similarly, if you look at 25.74, the court must not, it's mandatory, must not order an interim payment of more than a reasonable proportion of the likely amount of the final judgment. Well, how do you know what that is? Because it could be anywhere between £1 million or zero if the Section 57 defence succeeds. And what is to be avoided in this case? Master Fontaine's comments in this case was that what you shouldn't be doing is conducting a mini trial on the question of fundamental dishonesty, because, and rightly so, there's potentially serious allegations. That needs to be determined at trial, needs to be properly scrutinised, properly tested at trial. So it wouldn't be appropriate to conduct a mini trials to decide, well, I don't consider that the Section 57 defence would succeed, or vice versa. So for those reasons, where allegations of fundamental dishonesty have been put forward, my reading of this case, I don't know if it's being appealed, is that it is not appropriate for the court to order an interim payment. You'll find there multiple text comments over the next 2 slides there. I think these will be available after talking any about. And there. Now, Simon has said that he wants as many questions as possible.
Indeed. I'm just trying to find out where they are first. This is issue number 1, but bear with me. I think we're going to... Yes. So, I saw a couple of questions coming in during the course of this. Let's have a look at what's been put in. Oh, well, so we have a question about whether fundamental disorder would trigger indemnity costs, and I suspect that came in advance of. Anything you want to add to what you've just said?
Well, I'd like to think I've answered that. I hope so. When would it trigger indemnity costs? So in a fundamental disorder case, well, if the so I'd say if you want a fuller answer, read the case I just referred you to. However, in brief, if you've made allegations, or if the defendant has made allegations of fundamental dishonesty, the starting point, of course, is that those allegations have failed, and then the court thinks, I suppose, that it was unreasonable for the defendant to pursue the dishonesty argument. Only in that situation, if the court decided it was reasonable for the allegation to have been pursued, then it's not, I don't think, going to make an order for indemnity costs.
I'm grateful. We've got a question here which is a good question. It arises quite a lot, which is where FD, fundamental dishonesty, has been established under Section 57(3). Some claimants are arguing that the heads of claim unrelated to the primary claim should survive, i.e. claims not related to PI, such as credit hire. Have you experienced these arguments from claimant reps? If so, have you successfully combated them? I mean, my experience is yes, I have, and no, I haven't. Is short answer. I mean, at certain defendant insurers, I have taken a view that the primary legislation does in fact only bite against, quote, the primary claim, and the primary claim is the claim for personal injury. So all the personal injury elements are under attack: loss of earnings, care, general damages, but other non-personally related, injury-related heads of loss, so in this context probably credit hire, damage to your vehicle, that kind of thing, they are unlikely, is my own view on this, to be caught by Section 57. There is, I can't remember the name of it, there is actually a case that's come out relatively recently that says, it's only a first instance, but says that in terms. So I think the answer is yes, they will make that argument, and they're probably right to do so. But I don't know if you...
I would agree with that.
It's a specific one for you, Bernard, so over to you.
Okay, if fundamental dishonesty is raised early and the claimant solicitors continue with the claimant is impecunious, is there any case law or your own view if the claimant solicitors paying defence costs will continue to run the case? Well, non-party cost order in theory, but... there is a case of, forgive me, and I'll need to double check the authority, but there's a relatively recent authority in terms of wasted costs, that the court has to be very careful about going after the claimants, or the defendant going after the claimant solicitors for pursuing the litigation, because it will depend upon all sorts of commercial reasons. There is a recent authority that effectively says you're unlikely to get wasted costs in those circumstances, mainly because, of course, for a wasted cost, it has to be unreasonable negligence or is proper conduct. And quite often, privilege won't be waived over the file, so you don't quite know what's been going on between the claimant and the claimant solicitors. Merely pursuing the claim, even if they're impecunious, even if the case fails, which I think is the point of the question, doesn't or is unlikely to give rise to wasted cost. But again, Bernard says it's always fact sensitive. Yes.
I think, is that all the question?
Well, we had one pre-submitted question. Which I'm really hesitant to bring up because I've got a rubbish answer, quite frankly. The question was, how would you maximise a finding of fundamental dishonesty? What steps should you take as a defendant? It's one that I discussed with Simon actually earlier on, and I think that problem with this is that it's really more a question of what the claimant does or doesn't do in cases of fundamental dishonesty rather than what you do as defendant. Having said that, I mean, I'm grateful to Simon for this, and I thought this was a really good answer, is that what would be really helpful early on is to apply the same forensic thought to your own client's case. An example which comes to my mind is if I'm acting for the defendant and if it's a low speed impact, showing my age there, a low speed impact case. And the entire thrust of the defence is that, well, this was such a low speed, such a minor impact that there was no risk of injury to the claimant. And the defence says something like there was just tapped bumpers, for example. And then the claimant, the defendant insured, when giving evidence, says, well, yeah, there was a slight bump, I felt the bump. Little things like that. So really derail the entire case. So I would say, as Simon has said, that applying the same forensic thought to your own case is useful. And I would add to that, if possible, and it's really easy for me to say, but if you can get your ducks in a row, if you can get your own witness evidence essentially finalised, you don't have to serve it, of course, but your own witness evidence ready where it needs to be, even pre-issue if possible. I know that's often wishful thinking. You know what your strong points are, and you know how they're going to stand up to the claimant's evidence. But also, it can, if it's pre-issue, again, wishful thinking, in the defence, you can tailor your defence to those strong points, and you can open up the way potentially to an adverse inference against the claimant who invariably will not address the strong points of your defence or might seek to equivocate on the matter. So the one other thing I would say is, simply repeating what I've already said today, is satisfy yourself that it was reasonable to allege fundamental dishonesty just to avoid the risk of indemnity costs. And one final thing, I would also say, if you're going to allege it, make it unequivocal. So in correspondence early on, that will be enough, quite frankly. I think you'd agree, wouldn't you? If it's unequivocal, saying we consider this claim is fundamentally dishonest, that's enough. And it makes our job very easy, if we're acting for the defendant at the time, at the end of a trial, to say, not only was the claim fundamentally dishonest, but the claimant knew that that was our case, and no get out of jail card. That's me.
A couple more issues have come in. First of all, I'll pass on the credit / ship the blame, just in case it's wrong. But Roger Andre, who's also a barrister in these chambers, has helpfully put Williams Henry and Associated British Ports into the chat, for those who can't access the chat, as I think being the case that I was thinking of. I'll assume Roger just has an encyclopedic knowledge rather than Google, but it's the case that I was thinking of when I said that wasted costs are unlikely to be the outcome for pursuing a case, even if ultimately it's found to be dishonest. That does ring a bell, so I suspect Roger's right, but thank you to Roger for that. Cheryl has put in a good question, which is as follows: when is the best time to make an application to add the non-party for cost purposes? I mean, the answer to that is, the woolly answer is it's always fact sensitive. The slightly harder answer is that, of course, for there to be a non-party costs order, you have to have a costs order, at least the germ of a costs order, in your favour. The case law makes it clear that the judge who has dealt with the issue that you say gives rise to the non-party costs order should be the trial judge or the application judge. And certainly the practice that I've come across is that notice is given in advance of the hearing at which you think you're going to make the application. But you may not make the application because, for example, you might lose the trial, or, for example, you might lose the application, in which case you're not going to get a non-party costs order. But you put them on notice in advance, so they can't say they weren't on notice. And then at the conclusion of the relevant proceedings that you're dealing with, that's when you pop up and say, we told them about it, we'd like a non-party costs order. The other advantage of that, and this is pure sneaky defendant tactics, is that counsel for the claimant at that point is not instructed by the non-party. They're instructed by the claimant. And very technically, therefore, that counsel shouldn't really then be making lots of submissions about whether or not they should be joined as a non-party cost. For non-party costs, because they're not instructed by that body. And so it has the slight tactical wheeze that most judges will then join that third party. Of course, you then have to have a further hearing in which you will then decide whether an order should be made. Again, my practical experience is a lot of credit hire organisations, when faced with having been joined, look to compromise the costs order and therefore make a voluntary, effectively, non-party costs order without taking it through to trial or for a substantive hearing. But I think, so the short answer to your question, Cheryl, it always depends, but you can't really make it in advance because you haven't not necessarily even going to get a cost order in your favour, but as soon as you can. But as I mentioned in one of the cases, you don't have to do it at the end of the trial. You can revisit it, but you need to get, for the reasons I've already said, the trial judge to actually deal with it. Would it be right to say, another question, would it be right to say that FD and indemnity costs run the same threshold as civil fraud?
Well, I think the short answer to that, and Sam, correct me if I'm wrong, I'll say no, it's not, because the threshold is a normal civil standard for fundamental dishonesty, which is on the balance of probabilities. So if the court finds, even ever so slightly more likely than not, that the claim has been dishonest, that balance of probabilities, then the order must be made. Indemnity costs, I don't think, is a question of balance of probabilities. It's simply a question of, which is why I took you to the judgment from Lord Justice Coulson, whether or not it was essentially there's a high threshold that has to be passed. So it's not actually necessarily a question of balance of probabilities. It's simply fact sensitive and whether or not a high threshold in relation to conduct has been cemented.
Catherine has put in, I won't read it all, it's quite a lot, it's a comment rather than a question. I hope you don't mind me saying, Catherine, but it's making the point that in the Williams-Henry case that Bernard was talking about, the claimant's dishonesty, and I'm just going to read this section, the claimant's dishonesty went to pretty much everything, including, it said, what time she left a Spice Girls concert. I'm just going to pause there. I'm not quite sure. Is it dishonest to say you left early or to claim you stayed to the end when you didn't? I don't know. But that's absolutely, I think it was a very much root and branch dishonesty with the starting point of a obviously quite serious injury in the first place. But I'm sure that did factor into the court's thinking. I think that's all the questions. Let me check. No one has popped one. Oh, no. Some of you have done what I asked you to do, which is put in the question and answer, so I can only thank you.
Should we just take one or two more, because it's getting on about.
Are you able to see? Yeah, what's the best time to make the application? Yeah, done with that, Cheryl. Thank you. Sure, if that's a volume D to morning. Of the proceedings. So question is, instead of arguing fundamental dishonesty and to head off the Section 57 argument that we talked about, substantial injustice, could you instead just make an application to strike out the case on the basis that the dishonest conduct obstructed the just disposal of the proceedings? I think the difficulty, I mean, you might, but you'd have to prove that the dishonest did in fact obstruct the just disposal of the proceedings. Section 57 only rears its head when you've got partly genuine claim found proven and partly a fundamentally dishonest claim, and it's fundamental dishonesty that takes out the genuine part. If in fact you've got to the point that the whole thing is just such a mess that you can't make any findings because of the dishonesty, then the claim should fail actually, and you might be able to strike it out. It's probably a bit late to strike it out because to get to those findings you've had the trial, in which case you're actually dealing with substantive matters. So possible, but I think it probably won't arise that often on the facts.
Yeah. If there's one more, if you just take one more.
The non-party order, how do you establish non-party had control? So again, control of the litigation, always fact sensitive. This is the question, sorry, I should read out is, with a non-party cost order, how do you establish that the non-party had control of the litigation? As I was saying in the talk, I'm not sure control is any longer the touchstone, albeit it's relevant. In credit hire context, the control is given by reference to the terms and conditions of the credit hire agreement. That credit hire agreement will say, for example, the claimant either should or must instruct solicitors for the credit hire company. It will say that you don't have to pay us until the conclusion of the litigation. It will say that you give us the right to bring the claim if you don't. Every terms and conditions are different, but that is the hook on which control can be hung, because that's what gives the credit hire company then control over the credit hire claims, then forms part of the bigger claim. So that's where you should be looking for the issue of control. I hope that, I know it's an anonymous attendee, so I'll give you an anonymous answer. I hope that answers the question.
That's all the questions, actually, I think.
I think it is. So I think it probably just remains, unless someone fires one in very quickly, it remains for us to say thank you very much for listening.
Thank you.
I hope we've dealt with your questions. I speak on Bernard's behalf, but I know him, so I'm sure he won't mind me saying this. If you have any specific questions that either we didn't deal with or you would prefer to send in, so it's not in front of the class, so to speak, do email us if we can deal with them. Our email addresses are on the website. It's initial, so bpressman@deckerchambers.com, strigger@deckerchambers.com. It's the same setup. So if people want to send in emails because they don't want to share, that's absolutely fine. Other than that, I think that's. I see someone did just fire. Oh, no, good. Excellent. You're more than welcome. Thank you very much. If I can, I'm going to disconnect the hearing at this stage and wish you all a pleasant afternoon.
Thank you very much, everyone.